also extend my heartiest welcome to Ganesh ji, National Co-Convener Think India, and our chief guest, Advocate Namit Saxena, practicing before Supreme Court of India as well as other courts and tribunals countrywide. Enrolled with Bar Council of Rajasthan, Mr. Saxena, after graduating in law from National Law University, Lucknow in 2013, he was selected to work as a legal clerk cum research associate in Supreme Court of India. Mr. Saxena has a dedicated taste for academic writing and has published articles with various newspapers. Mr. Saxena is also the revising author of 22nd edition of Ratan Lal and Dheeraj Lal CRPC, latest edition of Mulda CPC and Sarkar Criminal Minor Act. All these are published by LexisNexis. Now I would like to welcome Mr. Namit Saxena to address this gathering.
Thank you. A very warm welcome to all of you, Ganesh friends. There's this very famous saying by Francis Bacon. He said, "Reading maketh a full man, conference a ready man, and writing an exact man." Now, man includes humans, not all words. The topic I'll deal with today is legal writing. Legal writing is something like everybody can write. There's no a very hard line as to who can write, who can write. Anybody who knows language, knows grammar can write. But legal writing, when it comes to legal writing, it is a very specific branch which requires in-depth knowledge and a creative attitude towards how to share your knowledge with others, with your readers, and a taste of how your writing will be debated. Now, for legal writing, basically, you can divide it into, you can write for journals, you can write for magazines, you can write for law reviews, you can write for newspapers, you can write research papers for, other non-law related journals like Economic and Political Weekly. You can write for websites like Live Law, Bar and Bench. You can write for a very wide range of various forums. But for writing, because whenever you write something, it should be debated upon, it should be discussed, it should be cited, it should be relied upon, quoted. That is the point of writing, isn't it? Otherwise, you write something and it is not debated or not discussed by anybody, then it is a waste. So for developing that, a particular thought process, a particular mind set up, develop something, write something, craft something which people or readers will, they'll generate an enthusiasm in themselves to read. For that you have to read a lot. The first step is to cultivate habit of reading. Now, to read what? Now, Justice Adv Namit, Justice Chalameshwar, and a lot of judges, a lot of renowned lawyers, and they are, in one sense you can call them bookaholics. They're always reading. You'll always find a book in their hand. Now, this does not come in, and this comes gradually. But the first step is to cultivate a habit of reading. Now, to read what? Now, there is legal literature. There are various books, Granville Austin, Subhash Kashyap's books on Parliament and Constitution, then Courtroom Genius on Nani Palkiwala by Soli Soramji and Arvind Tata. These are initial readings which, as law students you must read. Then after, then the other, like Charles Dickens wrote the Pickwick Papers. It's all about wonderful read. John Grisham novels, they're very common things, but they'll help you cultivate a habit of reading. You'll slowly start grasping how writers write. How, whenever you, for example, if you're reading, a very short novel or anything, a particular piece of paper, which ranges up to around, say, for example, 50 odd pages. Now, when you write 50 pages, now the reader, when he starts reading from page 1, he'll slowly catch up with the speed. He'll read till page 5 or 10 slowly, then page 10 to 40, he'll read very quickly. 40 to 50, he'll, because he does not want it to end, perhaps, or maybe that will depend, then he'll read it at his own pace. But you'll realize after reading, okay, this is how I read something, this is how I read the manuscript. Now, once you know that this is how I read, well, then this is how human tendency also works. definitely develop an understanding that when I want somebody to read something which I wrote, I want him to read on, him or her to read on these lines. This is step one. Now after literature, after initial literature, you should move on to serious literature. Uh, Not from fiction to non-fiction, it ranges from a very wide area. It covers a very wide area. George Orwell's Animal Farm, 1984. These are very good reads. They develop, in your mind a thought process as to how a few things can be written and few, untouched areas can be traced in your mind, and you'll develop as to how I want something to be written. Now, when you read all these things, the next step you'll move on to is discussing about them. Now, for example, she read something, she met a friend, or she knows a friend, or she is friends with somebody who also read it. They will tend to discuss it. Okay, this is what I wrote, this is what I read. Now, she may understand it in a different way, different context. She will understand it in a different context. They discuss it, they debate it. Okay, no. For example, a very casual conversation. This is how human mind works. Say, for example, 1,000 Splendid Suns. Very basic novel. Lot of people read it. So she read it, he read it. They discussed. They came to a conclusion. Okay, both of us were wrong. The author implied something else. Now, when a writer writes something, say for example, the curtains are blue. For example. The writer may have implied, okay, the curtains are blue, but the readers may read it in a different context. He'll say by blue, the writer may have meant something. This may be metaphorical. This may, in a larger context, mean that he wanted to imply that the curtains are blue means nobody can see inside. This defines opaqueness. Now, this is how you interpret things, and this is how the mindset, the thought process of reading and after conferencing, it develops. Now she says, okay, no, the author only meant the curtains are blue. What are you saying? There's nothing called opaqueness, there's no metaphoric in it. She will say, no, you read it in the larger context. Then they debate upon it, they have a conference in it. Now this is how Francis Bacon also defines it. Reading, conferencing a better man, and then writing a complete man, an exact man. Now then, once you are done reading, discussing, debating, conferencing, then you will tend to start writing. Now this is how I started. Liveblog gave me a wonderful platform to write upon. When I was a law student, I hardly used to write. I used to read a lot, that helped me. But I was never a prolific writer. It is only after graduation I got a lot of time when I was working as a law clerk with Justice Korean Joseph. I got a lot of time to write, and that helped me. That will help you eventually when you join the profession. Whenever you join a profession, especially you are all law students, you will join either as a corporate lawyer, or you will write for your judicial services exams, or for UPSC exams, or you will join the bar. In all those four things, and even if there are 5th, 6th, 7th profession as well, all of them will include drafting somewhere. Now, as a member of the bar, you will have to draft petitions, counter affidavits, legal notices, very basic legal notices. Now, for example, once you graduate, a lot of relatives will, jump in, say, beta, this is that happened to me, and they did not credit my salary. What should I do? The first thing you'll tell them is, I'll send a legal notice on your behalf. Now, to draft that legal notice in a wonderful manner, and in a manner which somebody cannot, accept and throw away without acting upon it, that is the art of drafting. That you'll only be able to do wonderfully well if you are well read, if you are well debated, well discussed, well conferenced. And that comes good. I'll come back to it. Now, for example, if you, instead of joining the bar, you go and say, okay, no, I want to be a judge, I want to be a civil judge, I'll write judicial services examinations. They also subjective papers are there. In a time-bound manner, you have to write wonderful answers. Because the syllabus is very well defined. Everybody will read that syllabus only, everybody will read the same statute books, and everybody will almost write same or the other answers from case laws, but it will be mostly the same. But then how to generate a different identity? Why should the examiner or the checker, whosoever does it, should give more importance to what you wrote. That comes through reading, conferencing, and again, once you start writing, you have to keep on practicing those answers. That is a different. Even UPSC exams, in every field, writing, because in UPSC exams also most of you will choose laws optional. That will help you everywhere. Now coming back to legal writing particularly, now how do you start? Reading, in-depth knowledge, all these are, helpful factors. But once you start writing, how do you start writing? You have to, for example, you have to write down, say where a lot of ink is already flown. For example, say the Kaushal judgment, section 377 IPC judgment. There's so many articles and so many, lot of stuff has been written on the model. Now, why should somebody read yours when there's already so much literature on it? Then you'll have to pick and choose something which is already not there. For that, again, you'll have to do a very hefty exercise. You'll have to read and research about a particular topic. For example, section 377 IPC. Now, what does the High Court judgment is there, Supreme Court judgment is there, the Supreme Court also dismissed the review petition, the curative is pending now. This all is readily available. Now, the Supreme Court pronounced the judgment on 12 December 2013, that is roughly around 4 years. Review petition was dismissed, the one-line order. Review is not, there are no grounds for review, the Supreme Court dismissed it. Now, since 2013 till 2017, December to November perhaps, a lot of developments have taken place. Now we have, in Rajasthan we have, in the Nalsa judgment, the third gender was recognized. Now in most of the exams, if not all, there's a category male, female, others. Now a lot of, developments have taken place. Now in case you want to write an article on this, you won't write an article on this happened. There was this concept of decriminalization and differentiation and legalization and decriminalization. What is criminalizable harm? There's already so much ink is flown. You'll write on what all developments have happened after the judgment, after the Supreme Court said, okay, no, it is valid in India. What all did happen? What all did the ruling establishment do? So this is how, this is, for example, I'll leave it up to you, trace it to your wisdom and leave it up to you, so as to what topic do you want to choose and what topic do you write upon. But this is how you should start researching. Whenever you research very, with passion, and devote yourself to it, to research work. Research is also a very important angle of the profession. Once you go to the bar, you join the bar, research is very important because you should never go before a judge, without thorough preparation. Judges will, grade you like anything. That is okay, that is another angle. But when you start writing, you should be very well researched. You should have, a dedicated folder of your research work on it that eventually help you in other topics as well. Say for example, you want to revise something which you wrote way back in 2015. Then you'll open that folder, you'll see, okay, this is what I researched then, and these are what developments have taken place. And you have to keep updating yourself as well. There was this Gujarat High Court judgment. There's this prince from, I guess, Jamnagar or so. His sexual orientation is slightly different. So there was this. One movie was made on him, and it traveled to the Supreme Court as well. That is still pending over the High Court. There's only one observation made in the judgment. But this is how you should, keep yourself updated. You keep, revising things. Then, like for example, this is only one part of it, 377. Then, after your research work, you have to always try and do. This is what I also practice. Always try to write the first draft. Okay, that this is the very basic draft. Just with the key points and just form the sentences and use the paragraphs. Okay, this is where I want to break paras, or this is how I want it to be, run smoothly. Then once you are done with the first draft, keep it. Just give it another thought, give it second thought. Like, okay, this I missed. Revise it once. Then come to the second draft. Second draft should be with all, nowadays, because you have to use a lot of jargons, you have to use quotations, you have to, develop an interest, you have to use your knowledge of history as well, because law is something, law as a science is connected with history, economics, politics, with, every other field law is connected. So you have to, try and connect dots as to how, frame a proper argument. And then you have to be, in case you are, and then there's this differentiation between analyzing something, evaluating something, criticizing something, and suggesting something. So when you analyze something, in case, for example, you're analyzing a judgment passed by the Supreme Court, you'll just simply analyze it, that okay, this is how it traveled to the Supreme Court. In case there's a dissenting judgment, see, two judges said this, the majority view is this, and the minority view is this, and then subsequently also, very interesting questions arise. Like, for example, if there's a 5-judge bench judgment with a majority of 5:0, they said, okay, that X is Y, and a subsequent 5-judge bench doubted its correctness and referred it to a 7-judge bench. Now the 7-judge bench by a majority of 4:3 says, okay, X is not Y. Now the 5 judges of the same court, because Supreme Court is the highest court, Supreme Court's judgments are although not binding, but when a constitution bench is sitting, they are binding upon all, because under Article 141 is law. So when 5 judges of the same court said something, okay, X is Y, and 4 judges subsequently, maybe of a larger bench, if they are saying it, okay, no, X is not Y, and how to go about it. All these are very interesting questions of law which you'll gradually learn. The answer is that, okay, 7 judges, because it's a bench of 7 judges, it is binding upon the 5-judge bench as well, so it gets overruled. So then you subsequently, you decide, okay, this is the majority view, this is the minority view, and this will be treated as the view of the Supreme Court. So, and then you analyze, okay, this is what they said, X is Y, and the reasoning. Why X is Y? That is very important. And in case they are overruling something, or in case they are propounding something, that further becomes very important. So this is something when you analyze, when you evaluate something, for example, you are evaluating the same judgment which the Supreme Court says X is Y, then when you evaluate it, you'll use other sciences, you'll borrow from other textbooks. Also make sure whenever you borrow something, cite it. Do not, because at a nascent stage, you should never encourage plagiarism. Do not use anybody's writing without citing it. So in evaluation, you'll borrow, say for example, in case you are a history buff, use something from the history. In case you are interested in economics, use something which Marx said, or perhaps any other notable economist said. Use it, develop an argument, prepare it, and then inject it into your article, and then supplant it to the readers. Then if you're criticizing something, now in criticism there are, because you have to be careful whenever you are writing about a judgment, you have to be careful of contempt of court as well. So whenever you write an academic criticism, because that is a defense under content. So always try to be fair in your criticism. Whenever you say, okay, that the Supreme Court is wrong, because a spade needs to be called, a spade, tell them that, okay, Supreme Court is wrong, but always supplant it with your reasons, because they say for example, you are saying that the Supreme Court is wrong subject to my limits of comprehensions because of this, so that nobody can pinpoint. And then you can say, no, come. Again. So when you are criticizing something in the Supreme Court said, because the highest court, the apex court of the country, so then you must say that, okay, in my view, this is what the Supreme Court said, or this is how I interpret what the judges said, and this is how, or this is why I don't agree with them. This is how you should, criticize it. Never say very bluntly without any reason, no, Supreme Court is wrong because they don't know anything, and then and that recent just the Deepak Mishra episode as well. Avoid all those controversies because you are very young to, comment upon it. Then after criticism, in case you are suggesting something, for example, you're writing up on infrastructural laws, and you want to say that, okay, the buildings, especially the government buildings, should be disabled friendly. and you want to tell them, okay, that these are the suggestions I want to supplant, and you can use them because they should be, those slopes can be used, lifts can be used, and disabled, people can have a separate entrance or separate parking. Separate parking is almost their separate entrance, all these factors you may, for example. So, now they are, avoid any controversy or avoid, or to sharpen yourselves as well. You should use, expressions which are gender neutral. For example, instead of saying chairman, use chairperson. Instead of saying that somebody is handicapped or somebody is retarded or challenged, try and use differently abled. You should be very careful with the use of their, THEIR and THERE. THEIR is unka, THERE is waha. So all these things you should be very careful of, because this is what people look, and this is what people point out as a stationary ka difference. All these very small things, but a very sharp reader will point it out. So always be very careful of it, so that nobody can pinpoint that you wrote something. Always be very careful when you are quoting a judgment, especially a high court judgment, that it has not been overruled by the Supreme Court, or in case its correctness has been doubted, or it has been referred to a full bench and mention it. In case you want to rely upon a particular, say for example 377 judgment, again last foundation judgment. So it is a good judgment by Justice Shah, but it's been overruled by the Supreme Court. So today it stands overruled. So in case you are relying upon the 377 judgment, Delhi High Court judgment, mention that okay, Supreme Court overruled this on these lines because of these reasons. That is how that will come gradually once you start reading, and always make sure that you read newspapers. Always keep yourself updated. Never miss a chance to read a newspaper. Whenever, in case you are traveling, because you'll travel a lot eventually after once you graduate. You'll have to travel here, there, build up a career. So make sure that you always carry a book or a newspaper, and you're constantly reading something. That reading habit will take you to places. And always nowadays all of you are tech friendly. You have these apps on your cell phones. You can download Live Laws app. You can download RNN's app. Newspapers apps are also there. So you keep always in circulation. That okay, this is what is happening in the world. Keep yourself always updated. Then whenever you're suggesting something, try and suggest something which is already not there. Like for example, in case you're suggesting measures to improve something, try and suggest measures which are already not in place, or already not been suggested, or already not been looked upon. That will help you, because the reader wants to know always, because always treat your reader as very enthusiastic, very zealous of knowing what next. And so always try and suggest something which is already not there. And whenever you suggest something, try in case it is not something extremely innovative. In case you're borrowing something, okay, the US model says this, or for example the UK model says this, the Australian model says this. And this is where comparative studies also become very important. So whenever you do this, try and supplant or give power to your argument by okay, this happened there, this is happening there, this used to happen there, and then they improved it like this. This is how you eventually improve yourself, because writing is a constant process. Nobody can I can't say that I'm a very good writer. It's a process of constant improvement. Every time you write something, you will improve. And then choose your interests. For example, he may be very very fond of criminal law, so he wants to write something on criminal law. But his actual forte lies in, for example, IP laws. So try and develop an interest. Think over that, okay, this is something, or this is a topic which appeals to me. Write on that particular topic itself. Like for example, they have to write their internship experiences.
No, an article.
You have to write an article. So this is a wonderful opportunity, because they'll publish it as well. So try and write very beautifully. Try and write it try and write something which is already not there, which whenever they publish it, they give it to somebody, somebody reads it, somebody goes to the index, okay, this particular XYZ case note on XYZ appeals to me, I want to read it. So when he turns to page number 98 to read XYZ, he should or she should feel that, okay, this person has written very beautifully. So that is how you make your mark. And this field, particularly the legal field, demands integrity, identity, both of them. If you're not honest to your profession, nothing will happen. But your identity will only come once you're honest and integral. And second, you make a very strong attempt to create an identity. That will come through writing nowadays. It comes through writing because there's saturation now. There's so much inflow and the output is very less. So you'll have to, there's a cutthroat competition. You'll have to choose a field. Then say for example, and there's one more very important point which you must always follow, that is reading judgments. You are in your law school, you have a lot of time in your hand. I repent this, when I was in my law school, I wasted a lot of time doing other stuff instead of reading judgments. I ought to have read more judgments. So whenever your teacher discusses, for example, Manoj Narula versus Union, that's a constitutional judgment. The Supreme Court has said that we can't direct as to whether having or not having criminal antecedents of a parliamentarian should hamper his appointment or selection or election. We can only trace it to the parliament. We'll leave it to their wisdom whether they want to, under Article 74, 71, 61, 68, they want to appoint him or her or not. Very wonderfully written judgment by Justice Deepak Mishra. There is a concurring opinion by Justice Kurin. So when you read a judgment, now you read judgments, on different laws differently. When you read a criminal law judgment, you should read it from the last para, especially of the appellate courts, so that you'll know, okay, this man was convicted, this man was acquitted, or this man was granted bail. So once you know this, you go back to, unlike how you read a novel, especially a fiction novel, you go back to the first page and then start reading the judgment in that context. But okay, this man was convicted by the Supreme Court, now I'll read it as to why. So in criminal law, I find it particularly very interesting because there is direct evidence, circumstantial evidence, chain of events, forensics is involved, ballistics is involved. Now for example, when you fire, if I fire at Ganeshji at this range, the bullet will go straight. If Ganeshji is sitting, at the last bench, if I fire, the bullet will go round. Now this is something which will come only when you are reading judgments. In some of the other judgments, this will be used. Now, for example, lacerated wounds, how deep the wound is, how you differentiate between. Now in your criminal law, you'll all read the difference between murder and culpable homicide, amounting to murder or non-amounting to murder. So how do you decide it? Now, for example, I have a lathi, I hit Ganeshji's head. Now the skull or the scalp is broken into two parts. Now this is a vital part. In the doctor's view, this caused death. Now this is murder. If I hit Ganeshji's hand with a lathi, now this is not a vital organ. Even if the arm is broken, or even if there is a fracture, even if it's a deep fracture, this will not cause death. So even if he dies because of other injuries, I can't be called a murderer because the injury which I caused is not sufficient to cause death. Now this is what you learn when you read a lot of judgments, series of judgments. And always make sure that when you read a judgment, make note of it. Do not just read a judgment. No, not all judgments deserve a note. There will be a lot of judgments which, the two-page judgment deciding a bail application serves no purpose. But whenever you read a judgment, even that particular two-page judgment, you should know what particular grounds have been used to grant or to cancel bail. Bail is also anticipatory or whatever, a lot of factors are there. So this is also keep a diary with you, keep a register. And when you're, interning right now, make a diary, make an internship diary. I guess they have to make an internship diary with them as well. No? Keep an internship diary, because after 2 or 3 years you will see, because you may be right now assisting your senior with a particular judgment, uska order will come after, say for example, after you graduate. This is how courts function. So that will be a wonderful experience. Then apart from reading judgments, read a lot of, now there are magazines like Legal Era is there, Lex Witness is there, Practical Advocate is there, there's this India Legal magazine as well. Read all these magazines, then you'll develop a taste of law when you read all these magazines as to what is happening. And you should always, my senior once told me that a good lawyer knows the law, the great lawyer knows the judge, okay. But a practical lawyer knows everything but law. So you should know the law. You should know what the judge is, where the judge is from, what the judge, when he came to the Supreme Court before, that when he was a judge in Odisha High Court, say for example, judgments did he write. So read all his judgments, check how he thinks, how his views have been, and then try and use them. This is there's an art in advocacy. You know how to represent a case, how to present your client. All this you learn slowly, gradually. But all this will come when you're reading, and all this will come when you're writing. Because only reading, after 4, 5 years, 6, 10 years, you'll forget what I wrote, what I read. But once you write it, you'll never forget it. And this is how that will help you eventually in your career as well. So, develop thought process, develop a particular mind setup, have passion for writing, improve your grammar, improve your, because once you start writing as well, you'll also feel, you generate a confidence in you as to present something which you wrote. So this is how the profession works, and this is how I guess you should start. Thank you so much.